All right, hello everybody and good afternoon. My name is Evan Bask. I am the Programs and Events Manager here at the Idaho Nonprofit Center. I just wanted to do a couple of housekeeping items before I hand it over to Amy to lead this discussion and the rest of our panelists. All of the attendees, you guys will be muted throughout the presentation. However, feel free to utilize that chat and questions feature. We would love to have any questions or any comments addressed, and I am happy to address them out loud to our panelists here on the line. To all of our panelists, I have inloaded all of our slides, so they will go through. I just put you guys in alphabetical order so that we'll kind of go from one person to the next. How it will work in this session is we'll do a quick introduction of all of our panelists, and then we're actually giving each of them a certain amount of time to kind of go through some slides or some resources and just kind of briefly talk about some of these topics from their perspective. And then after that, we will dive right into questions. With that, I will hand it over to Amy and we can kick off the party.
All right, good afternoon, everyone. I'm so excited to see such a big number of people joining us for this webinar, and a special thank you to Evan for pulling this together and for all of our panelists. Just briefly, we really wanted to focus on all aspects of the legislation that has been passed. We've done a lot of work on really focused on the payroll protection plan, and there are some other SBA loans and options available. So we're going to cover some of that also in depth today, but there's a lot of kind of meat and potatoes to the legislation that we felt that we hadn't spent a ton of time kind of going over with you. So to that end, we were able to secure on super short notice a broad variety of really great experts to kind of share those different aspects with you. So we'll have Karsten Peterson, who is an attorney and a partner at Hawley Troxel. We also have Joe Pareto, who's the VP Sales and Marketing at First Nonprofit Group, and they're actually going to cover some of the unemployment pieces of the legislation from a larger organization standpoint. And then Larry Ingram from the Department of Labor. Also, and he has somebody who's in the claims department joining him as well. So there's differences in Idaho law and how that pertains to nonprofits, and they're really going to speak to those smaller organizations, those of us that have fewer than 50 employees. So they're going to cover kind of what that looks like for you. And then we have Leah Dunn, who's a CPA with Nichols Accounting. She's also actually going to spend a lot of time on some of the different loan options for us. And then at the very end, we'll take questions. So for the most part, you won't hear from me from here on. I will basically just be kind of turning it over to each presenter as we go. So Chris is actually going to talk about a lot of the aspects of the leave as it relates to the legislation. So with that, I will turn it over to Carson, and I'm going to turn my volume up so you can hear me better.
Okay, I hope everybody can hear me. Excuse me, I'm not on video. Would you like me to be on video?
Oops, I was muted. Whichever you would prefer, Carson. Also, feel free to let me know when you're good to advance the slide, and I can do that for you.
Okay. All right. Well, thank you for that introduction. You know, we're obviously in the midst of unprecedented times here with some emergency legislation that's been recently enacted. We're about a month into what has been called the Family First Coronavirus Response Act, and I wanted to talk and touch on a few of those things and the paid leave that is now available under that act. So next slide, please. So as I mentioned, this act, the Family First Coronavirus Response Act, I'll call it the FFCRA or Family First Act, this became effective on April 1st. And right now it's slated to remain until December 31st of 2020. There's two aspects of this act, two aspects of paid leave. One is for the 2 weeks of emergency paid sick leave for COVID-19 related reasons. And as we get to the next slide, not yet, but as we get to the next slide, I will show you what those specific 6 reasons are that may entitle employees to this emergency paid sick leave. Along with this, the FMLA has been expanded to really, in effect, add one more reason, one more criteria for leave. And we'll get to that reason in just a minute, that provides up to 12 weeks of paid expanded FMLA leave related to childcare, which, given our current situation with at least Boise School District now being closed for the year, and I assume others will follow, we will probably see that becoming more of an issue. This act as a whole applies to all private employers with less than 500 employees. So that obviously casts a wide net on a lot of employers on that. There is a possible small business or healthcare exemption in this act, and I'll touch on that small business exemption, what maybe once appeared to be fairly expansive to protect or exempt small business employers with 50 employees or less. I think in practical speaking, it's not going to be as much of an exemption as maybe one would think. There's also some tax credits available for pay that is made under these acts. So next slide, please. So the first component of the FFCRA provides 2 weeks of paid leave if employees are unable to work or telework. So there is that component. If employers have made the arrangements and it works for an employee to perform their job duties remotely, which many of us are now doing, employees aren't going to qualify for this particular 2-week emergency paid sick leave. There are 6 specific areas under this act in which an employee may qualify for this expanded or if this emergency paid sick leave. The first being is subject to a federal, state, or local quarantine or isolation order. Again, maybe at first glance this may appear that this would apply to a broad range of employees, but in practically speaking, and as the act operates, I don't know if how wide that would really include people, particularly because one of the provisions under the act is that an employee is only entitled to either components of this pay if the work would otherwise be available. So in other words, if an employee hours are reduced, if a workplace is closed because of lack of work, they don't fall under these protections under this entitlement, so to speak, for emergency paid sick leave. Or so keep that in mind. That may not be as expansive as that might look, given our current status of the whole state, being under a stay-at-home order, which is now it's set to expire midnight tomorrow. But I know that there has been discussion and hints from the governor that may likely be that may likely be increased in the duration. In addition, we have we're under in the city of Boise the stay-at-home order. Blaine County has one that I'm aware of, and so there are those to deal with. But there again, if an employee's workplace is closed or if they're reduced in hours, they are not entitled to this emergency paid sick leave. The second reason, and I think reason 2 and 3 are ones certainly that I've seen questions about from various clients, are employees that have been advised by a healthcare provider to self-quarantine. And that, what I have seen, that does not necessarily mean symptoms consistent with COVID-19, such as a fever, shortness of breath, chills, those kind of symptoms that we're all kind of familiar with in terms of what people are saying they have when they suspect they have COVID-19. But this also includes people that might be at risk. There's a particular reason, there's a particular basis under the regulations that if somebody has been advised by a by a healthcare provider to self-quarantine because they're particularly vulnerable because of some underlying health condition. That can also qualify under reason number 2. Reason number 3, those that are experiencing COVID-19 symptoms and seeking a medical diagnosis. That medical diagnosis usually means those that are in the process of being tested for COVID-19. And so there's going to be a group of people that fall in that category. The fourth one, if an employee is caring for an individual who is subject to a quarantine or isolation order, or has been advised to self-quarantine, that may, I haven't seen much of that come up yet. The fifth one, however, though, I'm seeing more and more come up, is caring for a child whose school or care provider is closed or unavailable, particularly now because we have the closures of the public schools and obviously many daycare centers or other providers are probably closed. And so we're going to see people fall in that category. The sixth one, an employee is experiencing any other substantially similar condition specified by the Secretary of Health and Human Services. I have not seen this come up, where there's not a lot of guidance out there that I've seen that in terms of what would qualify as a substantially similar condition. So that one, I think we'll see develop and evolve perhaps more, but that's not a big one right now. Next slide, please. Okay, the second, this slide highlights, I'm going to highlight an error on this. I'm sorry about this, but I want to make sure everybody is very clear, on my error. The emergency paid sick leave, and again, we're talking about the 2 weeks if an employee is eligible for one of those for one of those reasons that I specified on the prior slide. An employee is paid at 100% of their regular rate if the reason for their eligibility falls under, and this is an error I want to make sure everybody's aware of, it should be under reasons 1 through 3, not 1 through 4. So 1 through 3 on that prior slide entitles or makes an employee eligible for 100% regular pay. You can see the cap. It's capped at $511 per day, or $51.10 in total. If an employee is eligible and granted leave under reasons 4 through 6 that I talked about, and again, I think what is most likely the most likely scenario is reason number 5, where a child's school or place of care is closed. Employee is eligible for 2/3 of their regular rate if it falls under reasons 4 through 6. And I'm happy to share these slides with people, and I certainly correct that third reason if we need to. But please make note of the 100% regular rate is for reasons 1 through 3. So next slide, please. Okay, during the emergency paid sick leave, again, the 2 weeks, during leave, an employee is generally entitled to a continuation of their health insurance. And this 2-week pay includes all employees. There's no specific requirement on the length of duration of employment, which the expanded FMLA reason has, that we'll get to in just a minute. So again, this applies to all employees. Next slide, please. Okay, the expanded FMLA leave, this provides for 12 weeks of job protected leave if an employee is unable to work or telework. So again, this would exclude the situation where a person is able to telework if they're working remotely from home. And this only applies to essentially reason number 5 that was on my prior slide, because they must care for a son or daughter whose school or care provider is closed or unavailable due to COVID-19 reasons. So it's limited in scope on this one. And next slide, please. Some other points to keep in mind with the expanded FMLA leave is there is a duration of employment requirement on this. A person must have been employed for at least 30 calendar days, and there is I think there's some guidance from the Department of Labor in terms of how to count those days. But the The point being right now for this discussion, it's someone that has to be employed at least 30 calendar days. The initial 2 weeks, technically, under the expanded FMLA leave, are unpaid. And so it'd be the remaining 10 weeks that employee may be entitled to payment. However, in practical aspects, the employee picks up those initial 2 weeks paid under that expanded, under the emergency pay that we just talked about. So practically speaking, it becomes 12 weeks of paid leave at 2/3 of the regular rate. Also, something to keep in mind with this expanded FMLA leave is this new reason added does not add additional time to an employee's FMLA leave. So if an employee is otherwise eligible for FMLA leave and they have used leave already, they're not going to get additional time here. It becomes all part of the 12 weeks, and so they're not entitled to any more. Next slide, please. Here's just some resources that I thought would be helpful for people to take a look at. As I said, the Department of Labor has provided some answers to some frequently asked questions that continues to grow. I think it's well up to over 70. It goes through and it sets forth a scenario and an answer. Some really good information on that. I have another link there from the CDC that gives some information on COVID related symptoms, recommendations that they give, and things to look out for. Also, I provided a link there. You can see the EEOC, 2 EEOC links. These provide additional guidance. The first link, which would be the third in the list from the EEOC, provides guidance on some other frequently asked questions that the EEOC has gotten, and so that's become some helpful information. And they recently have updated that as of April 9th. They provided some additional information on that link, and I suspect that we'll continue to see some additional updates. Secondly, or the last link there from the EEOC, this was originally a document that the EEOC released some guidance in 2009 when the country was facing what's known as the swine flu, some guidance on that. You will see some updates in that document specific to COVID-19 and some additional guidance the EEOC has given and that might be helpful that I have also looked at. So I think that's the end of my slides, but that's kind of a high level type of view on the FFCRA. And so I appreciate the time to share that with you.
Awesome. Thank you so much, Karsten. And I just wanted to point out, we were actually getting a few questions, which was fantastic. So what we will do at the end, once we get through all the panelists, so you can chat in your questions. There's a way to raise your hand, in, I think, or chat in some questions. So feel free to either hold on to them till the end, or you can start chatting them in now. So when we get to the question time period, we can just kind of hit the ground running. And somebody did just ask, will the slides be available for download and review at the conclusion of the presentation? And I believe the answer to that question is yes. I know Carson said he would be happy to share, and Evan has all of the slides, so if our presenters are all in agreement, we can share them out with you. So with that, I'm actually going to now turn it over to Joe Gretto from First Nonprofit, and he is actually going to go over some state unemployment insurance information, and then after him, we'll have Larry from the Department of Labor kind of talk to us from the smaller nonprofit standpoint and kind of what that means for us as well. So I'll turn it over to Joe. Thank you so much, Joe. And again, thank you, Karsten.
All right. Thanks, Karsten. Appreciate it. Learned a lot listening in. Good afternoon, everybody. Amy, thank you very much for the opportunity. I'm sure Larry's going to cover stuff at the state level. I'm specifically going to be looking at things from the federal standpoint. Just look at a couple of sections that were specific in the CARE Acts from a nonprofit perspective on the state unemployment side, I think. So you can flip to the next slide for me. So Section 2102 is the pandemic unemployment assistance. And This is in which benefits are going to be provided to those who aren't eligible under the standard UC system, specifically those type of individuals that don't meet the able and available factor for work. There's specific medical reasons associated with COVID-19, as well as caregiver responsibilities that are essentially open up the door to receive unemployment benefits to these individuals that aren't normally eligible. In addition to that, it also includes independent contractors, self-employed individuals, gig workers, those that may not have had qualifying wages to be eligible under the standard unemployment system, or those in which wages weren't reported to the State Department of Labor on the normal quarterly. So there's two things going on right now. There's the functioning side of the standard unemployment system that's dealing with the lack of work claims type of stuff for those individuals, and then of course there's this new structure, the PUA. So this PUA program is 100% funded by the federal government. It works much like disaster unemployment assistance, for those who may be familiar with that term. Again, 100% covered by the feds. We are awaiting on confirmation as to whether or not reimbursing employers, and just to kind of clarify this, because you'll hear me use this term throughout a couple of slides. Reimbursing is an option that's available for 501c3 nonprofits as well as any governmental entity, which allows them, instead of paying unemployment taxes to cover the benefits for their former employees, they actually pay dollar for dollar to the state. Basically, they reimburse the state for any claims that are paid out to their former employees. So when I talk about reimbursing employers, that would be those that are in dollar for dollar responsibility. They're not paying unemployment taxes. So we're just waiting for clarification that any claims that are paid via PUA, so essentially if an organization at a local nonprofit has an individual that's diagnosed with COVID-19 or has been medically instructed to self-quarantine, collect benefits, that those benefits will actually be paid under the PUA and not charged to a reimbursing employer due to the fact that they're not covered under the state tax system. So we're waiting for confirmation for that. So anybody that's reimbursing, that's still kind of up in the air. Special note for the nonprofit community there at the bottom. This expansion of the PUA, as far as those certain individuals that normally don't participate in the standard UC system, this is going to provide unemployment benefits for religious organizations. And religious organizations are the one organization which are exempt from having to provide state unemployment coverage. So if that happened to be a choice that the religious organization made, in standard times, their individuals would be eligible to collect benefits, but under PUA, they are now eligible to file and receive benefits. Next slide, please. This section 2103 is unemployment relief for governmental entities and 501c3 nonprofits. Now, again, this is going to be specific to those organizations that reimburse the state dollar for dollar for unemployment benefits. Again, they're not paying state unemployment taxes. So 2103 provides 50% relief of charges for all benefits paid through December 31st of 2020. It also gives the states maximum flexibility to offer extended repayment terms. So as far as normally in the state of Idaho, at the end of each quarter, a reimbursing employer will receive a bill from the state, and they'll be responsible to reimburse the state for any benefit payments played out. So what they're looking at is being able to, instead of being responsible to pay that 30 days from receipt, putting out the terms to 60, 90, 120 days. So they're leaving up to states in regards to the repayment terms. If you're an organization is paying unemployment taxes as a nonprofit, then you're receiving full relief regarding this. Entities paying the unemployment tax or paying taxes as such, and at the federal level, they are looking at to absolve that from the employer's experience per se, which is something will end up being a decision at the state level. I'm sure there'll be something Larry will be able to talk about and shed some light for us. There have been 9 states already to date that have gone beyond the state's 50% relief of charges, and they have applied full relief of charges for all employers, as you can see. Montana being closest in proximity to Idaho. So, for example, if you're a nonprofit organization that's reimbursing and there were, $50,000 of unemployment benefits paid to your former employees in this quarter, your financial liability would be half of that, so $25,000. And I'll just jump to the next slide. Thank you. Section 2104 is something that's been in the news quite a bit, and this is that $600 per week to the individual claimant, and the federal pandemic unemployment compensation. This is that $600, and this is eligible whether the individual is collecting through pandemic unemployment assistance, right, for those outside of the standard UC system, or those individuals who are on standard unemployment. We get the question a lot, is the amount prorated based on the amount of benefits in which an individual received? And that's not the case. It is $600 for all. If an individual is entitled to $1 of unemployment benefits, then they're eligible for the $600 stipend. So for those that may be on partial unemployment, whereas they're still attached to the workforce, they're still receiving reduced wages from their employer, and they're qualifying for partial unemployment benefits, they still get the full $600. That's paid on a weekly basis, and that will be available up through July 31st of 2020. This is also funded 100% by the federal government, and as I mentioned prior in 2102, we're still awaiting confirmations whether or not reimbursing employers are going to be treated like all other employers and have no financial liability on this additional $600. For the most part, nobody believes that's the case, but again, reimbursing employers have been treated differently through these situations before, so just kind of want to make sure so we can give you an idea as far as what type of financial liability you may be looking at. Next slide, please. And the last one specifically would be the pandemic emergency unemployment compensation. And in this case, this provides an additional 13 weeks to an individual who's either exhausted his or her PAU benefits or standard unemployment compensation benefits. Now, it'll automatically trigger after. So in this case, for those individuals, that's going to be an extra 13 weeks after they go through the initial claim. It's also 100% funded by the federal government. And just as the prior, we're just still making sure that this also applies to reimbursing employers, and they're not responsible for a portion of this additional 13 weeks. So from a process standpoint, the individual files, whether it be in the PAU or standard UC, once they burn through, then there's that additional 13 weeks as well. Now, there's also what's called state extended benefits, and not a slide I put together here, but potentially the way things are heading right now, if the unemployment rate continues to climb, and from an average standpoint, potentially there could be anywhere from additional 13 to 20 weeks additional in a program what's called extended benefits, and that's specifically state extended benefits. So at this point, no one is there. So the total amount of weeks would be the standard unemployment or the PAU plus the 13. So this is phase one. What we're hearing is we know that there's another stimulus package that's being worked on currently. And obviously the discussion of will these need to be expanded in any capacity will be forefront in regard to decision making. So that's all I have. If you have any additional questions, as Amy mentioned, she'll send everything out. My contact information will be on there for you. But thank you for your time.
Awesome. Thank you, Joe. We actually did get some really great questions chatted in as well. So at the end, I'll kind of go through and I'm sort of putting them underneath each presenter in my notes. So when I ask it, I'll direct it to a specific presenter or panelist. So the next person that we have on the call is Larry Ingram from the Idaho Department of Labor, and I know he has another individual on the call to answer some claims questions as well. And Larry's going to just kind of talk about Idaho and just share what the resources are that we have. And again, if you have questions for Larry, throw them in the Q&A or throw them into the chat and I will add them. And with that, I'm going to turn it over to Larry, and I know Evan's going to drive the bus on kind of sharing what your resources are. Thanks
Hello,
again, Joe.
Yeah, hi everyone. This is Larry Ingram with the Idaho Department of Labor, and I have to clarify, Idaho Department of Labor, not U.S. Department of Labor. So there were some questions that, or some topics Joe touched on. That would be the feds and not the state. And Joe, I have to say you did a really great job on presenting all that information. And I don't even know that I need to say anything anymore, other than your information was 100% accurate. But I can tell you what Idaho's position will be on some of these topics. Okay, Evan, could you go ahead and go to that first link we have? Maybe.
Yeah, let me just switch over my screens really quick.
And while we're waiting on that, if you look at the panelists, you'll see my name in there twice. The one that's one of them is me, and since I shared my invite, one of them is Gretchen Fontaine. She's the Idaho Department of Labor's UI Benefits Technical Services Supervisor. So she's all knowledgeable on all these different programs that Joe touched on. Okay, I just wanted to go ahead and give you some resources and show you where you can get at some specific information. And Evan, if you can scroll down a little bit more. See these three tiles right here: job seekers, unemployment, and employers. The one I want to talk about is the employers. And if, Evan, if you can click on down one, learn about employer services, and then scroll down a little bit. Okay, right here, unemployment tax help. If you can click on that one. It's right, yep, that one there. And then click on that blue tile, the employer handbook. If you had questions about financing methods, anyways, if you can go down, I think it's page 8. And you're talking about nonprofits. Okay, up one, government entities, nonprofits, basically governmental entities, nonprofit, 501c3 corporations, we consider them a covered employer from the first dollar paid. So these entities should be reporting wages, and that entity can choose a financing method. And if you can go down to page 20.
Everybody close your eyes while I scroll.
When I mention financing methods, they can choose to be experience rated like 97% of the employers in Idaho, or they can choose that cost reimbursement option that Joe spoke on. And let's see, down a little bit more. Here's a good explanation of it. And to give you an idea, experience rated employers, the lowest tax rate in the state is 0.255. which is about $2.55 per $1,000 in wages, but that can go all the way up to 5.4% right now, which is $54 per thousand. So that's tax rated, as opposed to a reimbursing employer. Let's say if you laid off one of your people and they were at max benefits, $434 a week. If they drew out for 13 weeks, that's $5,600. $6,642 that you would reimburse us for. So there's quite a difference, and you really have to take a look at it. And I don't want to dwell onto that too much, but to what Joe bring up, okay, so for cost reimbursement employers in Idaho, we have chosen to go ahead and subscribe to relieving or reimbursing that employer for 50% of the charges, and that will be effective for any weeks after March 13th. So the last 3 weeks of the first quarter, second quarter, however long this lasts, the feds will be actually paying 50% of the charges. If there's a nonprofit out there that is experience rated, like many of them are, if you lay off a bunch of people, those charges that would normally have been charged to your account, they'll be relieved 100%. Now, what won't be relieved, if there's a separation, if someone quits for a reason other than COVID, or they get, or someone gets fired and it's not related to the COVID-19 thing, you will still accrue those charges. Okay, Gretchen, did you want to talk about the different programs?
Good morning, everybody. This is Gretchen Fontaine. I'm going to just explain a little bit about how you guys file. The previous gentleman did a great job of explaining the different programs. I think it's important for those of you that may need to file, or your employees that may need to file, to know where they can go and do that. If you could please go back to our main home landing page. You will see, and then just scroll down just a hair. And you will see that under the section that says unemployment, if you click on the file for benefits, it is going to take you to what we call our claimant portal. All claims can be filed online. We are encouraging everybody that believes that they are eligible to collect unemployment to go ahead and file the claim online. You do that by registering in the system as a new user if you've never been in there before, with an email, and then you will create a password. I highly recommend that you encourage your folks that are going to file for benefits that they read the excuse me, questions or the guidebooks that are, or the guide sheets that are on there on that main landing page before they get started, because there's some good information that will help them successfully get through the claim filing process. Once the claim is filed, that is when we will take the time to determine if somebody qualifies for regular benefits. That is the first thing that we will be tasked to determine, is if somebody is eligible for regular unemployment compensation, then that's where they will be paid. The maximum benefit in Idaho is $448 currently. The minimum benefit is $72. So that's the first thing that we will determine once a claim is filed. If a person does not end up qualifying for a regular benefit, and there's a couple of different programs, obviously the main regular benefit, we also have folks that qualify for TRA. We may need to look at those as well, those benefits, before we consider then looking at the other options with some of the extra extensions that have come into play with, like, the PUA, for those folks that are, excuse me, not monetarily eligible currently, or are self-employed or a gig worker. We have to, like I said, first determine if they're eligible for the regular, and then if they're not, then we will turn our attention to determining if they're eligible for the PUA. Based off of some of the same criteria that was mentioned earlier, they have to be out of work related to the pandemic in some capacity for them to qualify for the PUA, but they can collect benefits if they're not physically able to go to work because of the pandemic, or they're taking care of a sick child or a sick person, or they themselves can't work because they themselves are sick, or they're having to stay home with their children. Some of those exact same guidelines that was mentioned before is part of what we are going to take a look at when the claim is filed to determine a person's eligibility. And that's all I have, unless we can wait later for questions.
I would like to add a little bit, if I may. Thank you, Gretchen. So just to give you an idea of this ramp up that we've had over the past few weeks, typically this time of year, we might receive between $700 and $800, or 700 and 800 claims each week. Okay, so that'd be like 2,400 claims, over the past 3 weeks. Well, anyways, since the governor declared an emergency, we've received more than 77,000 claims. So, I mean, it's crazy, you know, the amount of claims and stuff. Okay, to answer some of the questions that Joe presented, it is our understanding, and reading all the unemployment insurance program letters and the guidance from the feds, the $600 is paid fully by the feds. DUA is paid fully by the feds. The extension is paid fully by the feds. As far as the regular UI, we're doing a 50-50 split. So anyways, that's all I got, and thank you for your time.
Thanks, Larry. Appreciate it. This is Joe.
Fantastic. So I also got some great questions for the end. And then we'll, as we mentioned, we'll send out the slides. And if we don't get to everyone's questions, I'm happy to stay on and keep fielding questions, depending on what availability of our panelists are. So if people need to log off at 2, that's totally fine, but I'm happy to stay on and facilitate questions, but we'll make sure everybody gets answers, and this will be recorded and shared out as well. So again, thank you to Larry and to Joe. That was a lot of really good information. I appreciate your willingness to also answer questions even after the webinar is completed for everyone. So next up, we have Leah Dunn, who's a CPA with Nichols Accounting. And she's going to go over, she's going to go over the different loan options through the SBA. And I know a lot of us applied for the payroll protection plan. Some of us haven't gotten to it yet. So she's going to give some information on those as well as some of the other options. And I will just say that the payroll protection plan isn't necessarily always the best option for some of our smaller nonprofits. And she'll kind of explain what those calculations look like. So I'm going to turn it over to her. And again, as you have questions, feel free to ping them in the chat box or in the Q&A, and I am loading them up for our presenters to answer. So thank you, and thank you, Leah, for joining us.
Perfect. And you guys can see the correct screen, right?
Yes.
Okay, perfect. Thank you.
All right, thanks everybody. Excited to be here and hope to be able to provide you guys with some guidance during this always changing sort of situation. So I'm going to talk about 2 loan programs, the Economic Injury Disaster Loan Program, or just, I'm just going to refer to it as Disaster Loan Program probably, and then the Paycheck Protection Program, PPP. So if you want to roll to the next slide, we'll talk about the disaster loan. So you can get a loan for up to $2 million. This is a loan that is non-forgivable, meaning you will eventually have to pay it back. The good news is that the interest rates for nonprofits are only 2.75%. There's varied terms that you can come up with up to 30 years to pay it back, and you need to use those funds for accounts payable, debt payments, payroll, and other bills that are happening during the COVID-19 time. So in order to apply, you have to have your tax returns, 3 years of information, and you also have to supply like a basic balance sheet saying what other sorts of debts that you have. Next slide, please, Evan. Okay, so the program that's getting much more attention, I think, I guess I could be wrong about that. The one that I'm getting a lot of questions on is the Paycheck Protection Program, PPP. And so this is a program where you can actually have some of the loan forgiven if you use it for certain things. So in terms of eligibility, nonprofits are eligible, 501c3 or 501c9s are eligible, and they have to have fewer than 500 employees. The maximum amount is $10 million. And so the way that you figure out your loan amount has to do with your payroll amounts. And so there's a way that you treat non-seasonal employees and seasonal employees. And there's a few different time periods that you can use in order to figure out the amount of loan that you're allowed to apply for. So as you'll see on the screen, it's 2.5 times your average totally monthly payroll costs incurred during the year prior to the loan date. And so if you weren't in business in 2019, and you look at 2019, if you weren't in business in 2019, then you can use your January and February 2020 payrolls in order to come up with that calculation. For seasonal employers, you are able to do it for the average for the 12-week period beginning February 15th, 2019, or March 1st, 2019, and ended June. So really that would make sense if your peak period with seasonal employees happens during that window. Otherwise, it might make more sense to just use your average. We've been seeing clients that do have seasonal employees, and it really is working out better when you just use the straight up payroll amounts for the average amounts. So what counts in payroll costs? Salaries, wages, commissions, similar compensation. Anything for vacation time, sick leave, vacation days, things like that. Retirement benefits, group health insurance. So you basically take the sum of your normal payroll costs, and then you take out the excluded payroll costs to arrive at your payroll costs that you can use for your loan application. So let's talk for a second about the excluded payroll costs, which are on the next slide. So compensation is capped at $100,000. So anything over $100,000 needs to be excluded from the calculation. You add back federal payroll taxes, railroad retirement, income taxes, those sorts of things. If you have any employees that are living outside of the United States, you are not allowed to count them. And you have to subtract out any qualified sick leave under the Families First Act. So I know I've been seeing some of the questions in the chat. I'm trying not to look at them right now so that I don't get distracted. But the thing that's the most complex about all of this is the fact that you can't basically double dip. And so once we get to the Q&A section, we'll talk a little bit more about that. But you can't take out a PPP loan for wages that are being paid under Families First, for example, things like that. So there's some nuance that we need to make sure we get clear for everyone. Next slide, Evan. There has been some more guidance that has come out recently about sole proprietors, independent contractors, and self-employed individuals that they need to apply on their own. They are eligible to apply for PPP, but they're being carved out and they need to do their own application. Next slide. In terms of what you need to do to apply, you have to basically make a good faith certification that you are being impacted by COVID-19, that you're going to use the money to retain workers, and yeah, they're really just concerned about loan duplication and things like that. Is that the end of my slides? Yeah, okay, so you're able to get loan forgiveness for the PPP plan, and basically you do the same sort of calculation that you do in order to come up with the amount of loan that you're allowed to take. You do the same sort of calculation for your actual payroll expenses during, let's see, April and May, I believe, or I'm sorry, might be March and April. You have 8 weeks to use it, I guess. I guess it depends on when your loan is actually funded. So you have 8 weeks to use it from when your loan is funded. And if you use it for things like payroll costs, rent, any interest on a mortgage obligation, those sorts of things, then that counts. You don't have to pay those funds back. Next question. Oh, yep. And then these are other slides, but these are topics that the gentleman from Holly Troxel already talked about. So no need to go through those.
Awesome. Thank you. So I'm here still kind of on the line. I'm actually going to roll. I got 3 questions specific to the Small Business Administration. So I'm going to ask those real quick. So the question, there was two-part. We applied for payroll protection, but were declined because they're a 501c6, which those were not included in the PPP opportunities. What relief funding is available to us? I answered that they might be eligible for the emergency injury disaster loan, the EIDL. So I'm going to let you respond to that. And then she said they do have a 501c3 partner. Could they apply for payroll protection plan through their C3? So that's 2 questions from one org.
Gotcha. Okay, so they applied for the PPP, correct?
Correct.
Okay.
And they were denied because they're a C6.
Right. And so what's the question again? I'm sorry.
So the question is, it's twofold. What other options are available? Okay. And also, they have a C3 partner, so they're asking,
okay,
instead of other options, could they do PPP through their partner?
So my perspective is you would not be eligible to do the PPP through the partner because the payroll that you're paying was not paid through that partner. And so they're going to be looking at employee identification numbers, things like that. So you wouldn't be able to apply through that, but unfortunately, sorry. But you could still potentially apply. I'm just going to pull up. You could still apply under the Economic Injury Disaster Loan Program, but that is money that you would eventually have to pay back. But it would, so in a way, you're kicking the can down the road a little further, but at least you have what you need to stay afloat. So there's basically 2 different things in play here. One is if you simply have to lay off your employees, then that's where all the unemployment benefits come into effect, versus the loans and the PPP is to try to keep people on payroll so that they don't have to go tap into the unemployment programs.
All right, thank you. Another question came in, and it's just a logistical question. So someone applied for those, the emergency injury disaster loans on the SBA site. They said it's 4 pages. They did not request tax returns, financials, etc. And did they miss something?
I'm surprised that you didn't have to put any tax returns in. So, you know, I personally have not applied. I didn't handle our Nichols application. So I would assume if your application was accepted, then maybe that was okay.
Yeah, it's hard to say. Our advice was for folks to make sure that they reached out to their lender specifically. So, usually that's even though the SBA has the loans on the site, there were some, and congratulations actually for making it through the application online, by the way, because we had a lot of people that got kind of stuck when they used the SBA form versus the lender form, because there's some places that you just had to check boxes even if they weren't accurate. So that in and of itself is a miracle. But yeah, if you have a banker or a lender, definitely check in with them too. I would say just to kind of get their take on it as well and see if they can't maybe kind of swoop in and help you out with that. So I have a few more questions on the SBA loans, but we got some other good questions on the unemployment. So I want to kind of jump back up to the tippity top on some of those questions real quickly. So here's a question. I don't know if this is a Joe or a Larry, but what about seasonal employees who have received an offer of employment, but the future event may be canceled due to the pandemic? So what about, like, you should be working maybe a concert, for example, in the fall you've got, or you're going to work a series of concerts over the summertime. And so you have a job offer, but then all of those things get canceled. So what about folks like that? There's a lot of seasonal employees actually in our nonprofit world.
Gretchen, I think that one.
Larry, you want to take that one?
Sure.
Yeah.
Well, Gretchen, I think would be best.
Okay, yes, I can take that one. So we would encourage anybody that does find themselves out of work again, even if they had a current claim in the past that may have gone inactive or maybe has expired, we would first want them to go ahead and reapply. We foresee that's going to happen quite a bit in the next couple of months. People think they have a job to go to and then they end up not having a job to go to. That is also where some of the extensions will come into play. If they have exhausted their benefits, then that's when we can look to see if we need to then trigger them into the extended benefit program so that they can continue to collect benefits if that job does not start.
Okay, awesome. Hopefully that helps. So this is an interesting question that I want to, and I think this may be something that other people are curious about, but what happens to a person's unemployment benefits if they're receiving their average wages through the payroll protection program? Will they still be able to get unemployment payments, and will they still receive the $600 stipend? So that's a question that relates back to the both payroll protection and unemployment benefits. So what happens to those benefits if they get their wages through the PPP program? Are they still eligible to get unemployment payments?
So no, you would, and I don't see why you would need unemployment if you're still getting your PPP. If you're getting paid under PPP, you wouldn't need unemployment because you're receiving your regular paycheck.
Correct. That was my thinking.
Unless I'm missing something.
And yeah, okay. And then here's a couple of other questions. So, and these are logistical questions for people filing, but somebody wanted to know how long does it take to determine if they're eligible once they file online? So at what point will they know they're eligible for unemployment benefits once they file online?
This is Gretchen. So as Larry had mentioned before, we have seen a drastic increase in the number of claims filed. We are in the process of trying to work all claims from several different angles to get people paid as quickly as possible. We encourage the customers to continue to file weekly reports every week and to not stop, even if it does show that there is a pending issue on their claim. We are doing like I said, we have several groups working those issues to try to get them cleared off as quickly as possible. So we can't promise or guarantee a certain day or time that a payment will be released. So the best thing we can encourage folks to do is to continue to file. If they watch their payment summary screen, that is a good indicator that if there is an issue holding up payment, that it's been cleared and payment's been released, they can watch that screen in their claimant portal. That helps give them good information. And for those folks that are currently not monetarily eligible, and we're going to have to look at putting them on PUA, we are working on that program, getting the programming in place so that we can start looking at those claims and getting people eligible for those. They also need to be encouraged to continue to file weekly reports, and then we will watch our website. That's the other thing that claimants and employers can do, is watch our website to see when and how we need customers to potentially submit documentation to help qualify them for the PUA benefits for those self-employed, again, folks that are not currently eligible. So I think that answers the question.
Well, I think one of the things that we didn't mention or hasn't been mentioned, that one of the requirements or one of the things that Idaho agreed to for some of the federal funding is we did away with the waiting week. So if it's a very clean claim and there's no issues, theoretically, a person would file a claim this week, certify for the claim after the week's over. And if they're on direct deposit, they'd probably get paid within a day or two of the week completing. Gretchen, do you agree with that?
100%, yes.
And then
Awesome.
if I can go ahead and clarify another comment that was made earlier. Okay, just because a person is receiving continued payments from their employer if they're out of work, we require them to go ahead and report those earnings for the week when they were earned or attributed to. That doesn't necessarily exclude a person from receiving unemployment. Say if they were only receiving 50% of their wages for that week, they may still be monetary, or they may still be eligible and not disqualified because of the income. So theoretically, if they get at least one in a benefit payment, they'll still get the $600 add-on. So, thank you.
Awesome. Thank you. And so I had a couple other questions that were, I want to circle back for Carson. So, and this was a good one. So the Idaho stay in place was in effect before April 1st. So on your slides, on those qualifications, there was 1 through 3 and 4 through 6. And this is a question specific to that slide. The Idaho stay in place was in effect before April 1st. Does that mean the first bullet doesn't apply as a qualifying factor for the paid leave?
Well, the act is not retroactive, so anything before April 1st would not apply under the act. But starting April 1st, if you still have a person out, an employee out for one of those qualifying reasons, and again, it's important to keep in mind that a predicate to all of these is that work has to otherwise be available, or the person is not able to work remotely. So if it's an issue where the work just dried up, there's reduced hours, there's no protection under this act. But there is no retroactive application. But say you had somebody that is still out on April 1st, you need to start the clock then.
Perfect. Hopefully that helps answer that question. We're getting lots of really good questions. I think another one for you, Carson. So here, and this is an organization-specific question, but their facility is under isolation order at the request of the local hospital. Some employees can work from home. They're staggering hours, so there's no close physical contact. But staggering work hours results in an employee not being able to work regular hours and is losing pay. So how would reason 1 apply to those folks?
Well, again, I think this, under reason 1, this would potentially, I think the question falls under reason 1 here, is subject to a federal, state, or local quarantine order. If it's a local employer decision to do that, then that's not going to fall within qualifications under the act. I've had questions come up, from other employers, if they on their own decide to have a person stay home or to self-quarantine or reduce hours, that is not going to fall under the protections of the act. So I think that's the answer to that one.
Okay, awesome. Thank you. And then here's a question. This is a really good one because I know, especially for some of our larger organizations, they may want to have this question, and this might be a Carson or a Leah question, but are there guidelines on whether to use payroll tax credits or the PPE program to help cover those payroll costs?
So that's obviously a difference, like that's a opinion question. So I'll give you my opinion. First, you want to try for the PPP funds because they will be 100% forgiven if you're able to use them for the intended purposes, which I would assume that you would be able to. So the tricky thing is we're really not sure how long it's going to take for the PPP to start coming through. And Nichols is having another webinar tomorrow kind of touching on working with, we're doing it in conjunction with Columbia Bank on how to move through the application process, because just like the unemployment folks have been talking about from the state of Idaho, the banking industry has been flooded with hundreds of thousands of these applications, and they all need to be processed in a really short amount of time. So PPP is your best option in terms of, cost, I guess, but we need to wait and see what I'm not exact. We're just not sure how long it's going to take for the funding to come through. So part of it depends on the amount of reserves you have, I suppose, versus if you do try to take the tax credit, that is money in your pocket now because you're not having to pay for the employer portion of those taxes. So what I'm hearing as I talk to my colleagues is that it's better, the PPP is going to be better, assuming that we can get the money out and get access to it in time.
Okay, that's kind of what I was thinking as well. And another question that's sort of related to that. So, and this comes from one of the folks on the call. And I don't know, again, if you need to go, you've got something else, feel free. I'm going to just stay on as long as we can continue to address some questions, and then whatever we don't get addressed, we'll get answers and send them out. But the question is, there's a forgiveness requirement of maintaining staff? Is it headcount or FTE level, and is it all or none, or is there partial forgiveness if you drop any amount of staffing? So this question, the person says, I know we can cut wages by 25%, so it isn't wage-based criteria. So basically they're asking, can we still get forgiveness on the PPP if we drop some of our staffing?
Yes, so if you want to put the slide back up, Evan, of the loan forgiveness, the one with the little heart, yes, you absolutely can get the loan forgiven still. The things that you need to spend the money on during the 8 period beginning on the date that the loan, or the 8-week period beginning on when the loan happens, is you need to use them on payroll costs, basically using whatever the exact same criteria that you used to apply for the loan in the first place. Interest on mortgage obligations, rent payments, on lease agreements, utilities. So if you spend the money on those things, then the loan will be forgiven. So if you've dropped a lot of your staff, I'm just thinking through, if you've dropped a ton of your staff and you don't think that you're gonna be able to, that you're not gonna use the funds for these things that are up on the slide, then it converts to a loan, and it's like at 1% interest repaid over 2 years. So it's still very, very affordable in terms of loans. Did that answer?
I think so. I think that
Okay.
clarified it for me. Awesome. So I have rolling back to Larry and Gretchen if they're still on the call. I actually have a number of questions relating to the PUA benefits. So first question, when does it start up? Is it retroactive to when you file? And then I had another question from a nonprofit who they had to furlough some employees, and this is a pretty common thing that will happen. They had to furlough employees with expanded unemployment benefits. It seems like they might actually make more money per week on unemployment than they would if they were still working. Is that correct? So those are two kind of PUA questions for you guys.
Gretchen, how about you take the second one?
Well, that kind of depends. There isn't a real straightforward answer. If they file, and depending on how much they're eligible for and how much they're working will depend on if they're eligible for regular benefits. So that's a hard one to give a definite yes or no answer to. So again, if you happen to need to lay them off and they need to file, then that is when we can determine their circumstances. As far as well, I'll let Larry handle the PUA question.
Okay, so, PUA, it's disaster unemployment, pandemic unemployment assistance. It's a program that we commonly don't use in Idaho. We've used it in a few floods, for some floods in a few counties like 10 years ago. Okay, so anyways, we have to make significant alterations to our system, and we think we'll have it ready to go in May. But we can backdate payments to the week of February 2nd based on the federal guidelines. Okay, this emergency in the pandemic, the governor's emergency didn't happen until I think the 3rd week in March. So if people come in and file, I guess the short answer to your question is yes, from when they file. And I don't know that, anyone will meet the criteria to backdate to February 2nd, nor I don't think we would backdate a claim that far. So from when they file, and this program, I believe it runs the max for 39 weeks of payments, and it'll end on December 26th. Hopefully this is all done and over with before then, and we get back to normal. But
yeah,
short answer, yes.
Okay, great. Short answer, yes. Awesome. This is another question that came. I think this is the Carson question if he's on the line, but if anyone knows the answer, feel free to answer. And I think I know the answer, but I think she may have joined a little bit late. But does their nonprofit have to pay the emergency paid leave, or is that the federal government going to cover?
This is Carson. I don't know the answer to that. I wonder if somebody else might.
What's the question? Is it on one of the 2 programs I talked about, or is it talking about unemployment?
It's talking about the is the nonprofit going to pay the emergency paid leave, or is the federal government going to cover that?
So the Families First 2 programs.
Mm-hmm.
Well, Carson, you don't know the answer to that. Wouldn't it be based on however your unemployment insurance is set up at each individual business?
You know, this is actually one I haven't looked at yet. I haven't even had this brought up until now, so I don't know. That might be a follow-up question I could look into.
I'm guessing I mean, this is just a guess, that it's the same way that you file for any sort of FMLA type stuff, where you probably pay it and then get reimbursed, would be my guess. But that's just a guess.
Hi, this is Joe. There's actually two ways. You can just retain the employee and employer portion of the taxes and cover it that way. Or if that amount doesn't actually cover the paid wages up to the limit, you can apply for a refund with the quarterly filing. So there's really two ways in which they gave it, but the idea was to have the money in house by just holding the employer and employee portion of the taxes. So the money would actually be coming from the organization directly to the employee for the 2 weeks. And again, if it's not enough, then they can apply for a refund. I haven't really looked at the parameters in a couple of weeks, but I know that they launched essentially a how-to instructions as far as how to file for it.
So hopefully that answers. That is awesome to have all three of you on this call to help fill in those gaps. Here's a somewhat related question to the leave. If an employee has sick leave accumulated, do they have to use their own sick leave before emergency leave has to be provided?
No, I feel this was one that was answered in some of the Department of Labor guidelines. Let me take a look at that. If someone else knows the answer off the hand, let me see if I can find that real quick if you have another open question.
Okay, awesome. I actually have a number of questions still in the queue. Like I said, we'll keep it going as long as we can. So one of our employees had to cut their hours by 90%. They applied for unemployment, and they're getting a message pending issue stopping payment for the past 2 weeks. The information the employer has received does not show issues. What should they do?
This is Gretchen. I would encourage them to continue to try to call our phone lines. And also we have the click to chat feature as well. Those are the two best ways to get in contact with us. We do have extra staff out across the state that are helping triage and field some of those calls that are coming in so that we can route them right into a UI claim specialist. Some of them are going to be, those issues are going to be pretty straightforward, and we're going to be able to take care of them relatively quickly if they get through. Some of them may take a little bit more time to adjudicate. It just kind of depends on the issue. So we just encourage folks, like I mentioned earlier, to try to call or click to chat and then continue to file those weekly reports.
Awesome, thank you. And we've been getting some questions from folks that are sort of along the same vein, and we've been just telling them basically the same thing. I had another good question. Then this actually, we got a couple of calls. So the nonprofit did not pay unemployment insurance, and then they laid off their staff, but then they actually closed the nonprofit. So what happens, and there's a lot of our smaller guys are kind of in this boat. So what if the nonprofit didn't pay unemployment insurance, then they laid off their staff, and then they shut down? What happens to those employees who've lost their job and their employer no longer exists?
Well, the first thing on a claim for unemployment, is that person monetarily eligible? So has that employer reported the wage credits or reported the wages like they're supposed to? In those cases where they haven't, we would certainly like to see some type of information or documentation that can substantiate that individual's claims, and we could go ahead and get them on the system. But if you have anyone out there that, you know, unregistered nonprofit, I'd be more than happy to assign someone to work with them to get all those wages put on the system and make it pretty straightforward.
Perfect. So yeah, so I'll if I hear back from especially one particular organization, I will make that connection. So thank you. I was just so surprised that I learned a lot actually from that whole scenario that happened. Did you get an answer to our other question?
The one to me about if the employee has sick leave accumulated, must they use that, or can they use the emergency leave? That question.
There was that one, and then there was one that Larry was working on too. Maybe it was the same one. Okay. Well,
I think this is answered in the Department of Labor, and that link that I gave you. Look at number 46. This paid leave is in addition to what they have accumulated otherwise, so they don't have to use their accumulated, you know, sick pay under their employer policy.
Awesome. What happened? No, I won't ask that question. I'll circle back with you later. That was the question that I had. But another question that came in. So there's some more questions about that $600 PUA benefit. So, and we did ask if it started up and if it was retroactive. So we got that question answered. But we had some interesting questions. So some of our organizations are like social enterprise organizations. And so what if say they operate a cafe and they shut the cafe down? So they've got staff that would ordinarily, you know, maybe serve food, prep food, whatever. So so say for example, it's a waitress and they shut down, are they eligible then for that PUA? And then the other question is, just to clarify, an employee furloughed due to COVID-19 related shutdowns does not automatically qualify for the extended unemployment benefit. So that was another question. Does those two make sense to you?
Oh, go ahead.
So just so the question is, an employee furloughed due to COVID-19 related shutdowns does not automatically qualify for the extended unemployment benefit. So that was the question. And then the other question was, say for example, if a social enterprise like a restaurant closed because of COVID-19, does the waitress or that staff member get the extra $600 even though there was no work that could have been done, if that makes sense? There's two questions there.
They do make sense. And Gretchen, are you still with us?
Yes, I am. So yes, if a customer, again, is out of work because their business is no longer viable or working and they're not working, then yes, when they file, we'll determine if they're eligible for regular benefits. And if we pay them $1, then they will get the $600 federal pandemic compensation. And that's going to be the case if it's regular benefits or if it's the PUA benefits. Or if they have an exhausted claim and we have activated them on an extension, then they will also get that $600 up until the last week that they're eligible to collect it, which is at the end of July.
Sorry, I had myself on mute and I was talking and no one could hear me. I apologize for that. For getting through, we just have a few more questions. So I'm just going to do kind of a last call. If there are any other questions, send them into the chat real quick. This is a great question. Are employees that are collecting unemployment due to COVID-19 shutdowns also supposed to be job seeking? So this is a specific question from someone who is in that boat.
Most of our folks that are filing right now are not considered work seekers and they are coded as employer attached. That is one of the questions that we ask during the claim filing process, is that will you be returning to work with an employer, and if they say yes to that question, then they will not be required to look for work. That was one of the things that when the governor passed this emergency legislation, is that he expanded that to go past the normal 16 weeks in Idaho, and they can basically be attached to their employer through the whole time that they're laid off or not able to work. So if they answer that question when they file correctly, then it should properly code them as attached. If they by chance don't get properly coded, they just need to get a hold of us, and we are working on trying to get all of those people that should be properly coded, coded as such as employer attached. There are still a small handful of folks that will be required to look for work, but it's only because they, kind of going back to the employer that you mentioned earlier, if they have shut down their business and they have no means to bring those employees back to work, then yes, those employees would be expected to look for work.
Okay, perfect, thank you. And then these last two questions, so somebody wanted the stat from Larry. So we heard like 77,000 unemployment claims in the file. What happens in a normal week for claims? So they wanted a repeat of that stat. And then, and this is a great question too. So for a nonprofit that's self-insured, how is that going to affect what they get charged if they're self-insured for unemployment benefits? So those are my last two questions that I have.
Okay, so normally this time of year, each week, we'd be seeing approximately somewhere between 700 and 800 claims, new claims being filed, and that's historic, during normal times. Okay, so in the last 3 weeks, if we look at a prior year, let's say 2,400 claims. In the last 3 weeks now, this year, we've had 77,000 claims filed. Okay.
Wow.
That's a huge jump. It's a huge. I think if you look at the media or what I've heard on Channel 7, and this came from our folks, we've already made 60,000 payments out to unemployed individuals. I think it was in the tune of $18 million. I could be off on that dollar amount. Okay, wow. As far as the self-insured, same, that's cost reimbursement. The feds will be paying 50%. So this first quarter, I'm sending out billings next week. The amount that we will pay, or that the feds will pay, that we're computing, it'll be for the last 3 weeks. It'll be 50% of the last 3 weeks on any charges that you have. I know this affects 400 nonprofits is what we have so far where they have charges for that period of time. I don't have the dollar amount worked out on that yet. Have the employers figured out and stuff like that. So.
Okay, perfect. So I did actually, I have a couple of other questions that sort of popped up from their questions that I think all of us would want to know. And this might be a great one for Carson if he's still on the line, but can we ask our employees if they've tested positive? Let's say we've had an employee and they've called in sick, they didn't want to say anything. Can we ask them if they've tested positive as an employer?
That's a great question, and the answer is yes on that. With the concerns related to COVID-19, and the whole idea is they're trying to get this under control, trying to prevent the spread. There is greater flexibility now related to those questions. So you can ask them if they've tested positive. You can also ask if they, what type of symptoms they've had. You know, if they call in sick and say, I'm sick, I can't come, you can ask, symptoms consistent with COVID-19, with fever, cough, shortness of breath, some of those things the CDC has outlined. So those are appropriate questions. I will throw this in because I think it's kind of a related thing. If in fact you have an employee that does test positive for COVID-19, employers want to be very careful about maintaining that individual's privacy. You don't want to be identifying who that employee is, but it is appropriate to share some general information such as, we do have a member or an employee here that has tested positive, and those that may have had close contact with that person, will be notified individually. Now, obviously, if you're in a smaller type of employment setting, by process of elimination, one might be able to figure out who that positive test was. But I just want, as a general rule, you want to do what you can to maintain confidentiality. But at the same time, you know, you as an employer are entitled to know who tested positive to COVID-19 and, you know, report that to the respective health district.
And as a follow-up question to that, I actually have two. So one of them is, can we require a doctor's note before allowing an employee that tested positive to return to work? And then the second, sort of piggybacking on that, is if and when employers are required to pay for the testing.
Well, the answer to the doctor's note question is yes, you can. You can have a doctor's note that states when an employee is cleared to return to work, and you know there's different guidelines that continue to kind of shift and move, you know, in terms of when a positive test person can return to work, and it's complicated now because what we're learning is so many of these symptoms are asymptomatic, you know, and so the employee wants to work with their doctor, but the employer can require that type of note. And what was the second question?
If and when employers are required to pay for the testing.
Well, a lot of the times here, the health insurance benefits are if they are, you know, if there is health insurance provided by the employer, health insurance is paying, you know, for that. If an employer is required to pay for the testing, I don't know the answer to that, but it seems like it would be in the best interest of the employer if they have a question on that. They certainly don't want COVID-19 spread in their workforce. So I'm hoping that they would be willing to pay for that test if necessary, if there's a suspicion that a person has the symptoms or exhibiting those type of symptoms.
Okay, perfect. Yeah, it's a lot of our smaller nonprofits of those with a budget of, you know, like under 350, 400,000 don't necessarily have pay for employee healthcare benefits. They may have them through a spouse or a domestic partner, but not always. So I think that's where that question was coming from. So if they didn't happen to have insurance that would cover it. But yeah, they're.
And you might reach out to the health districts too, because what you don't want, the whole idea here is we're trying to prevent the spread. And you know, you definitely don't want it in your workplace. If you're in a situation on a testing issue, I think it'd be worth contacting the health district to see what other options are available. But you know, if you're stuck in that situation and in the meantime looking for that answer, if you have that suspicion, you know, you as an employer, I hope are considering, you know, a self-quarantine for that individual.
Yep, perfect. And then I actually have one more on just kind of employee privacy, but can we take employees' temperatures when they're reporting to work? That's one of the questions that came in.
Yeah, yes, that is specifically allowed to take employees' temperature and to keep a log, you know, of that. Again, you want to maintain the confidentiality outside of HR, but that is specifically an authorized thing to do right now.
Okay, perfect. And I have kind of two FLMA questions and then one sort of related. So the question is, how do you, and this popped up earlier, how do you calculate those, so that an employee has been employed for 30 days? So how do we calculate if an employee has been employed for 30 days for the expanded FMLA leave? And that was, I think and Larry, you may have addressed that. I was answering a lot of questions.
No, and the FMLA questions, I deferred and said that's federal Department of Labor, not Idaho Department of Labor. So it is a wage and hour question, but a federal wage and hour one. Okay.
And then here's another great question.
Just real quick on that question, there was an example posed to the Department of Labor in that link that I had sent out about that. It's an answer to question number 14. I'll just read that real quick. It says you are considered to have been employed by your employer for at least 30 calendar days if your employer had you on its payroll for the 30 calendar days immediately prior to the day your leave would begin. For example, if you want to take leave on April 1st, 2020, you would need to have been on your employer's payroll as of March 2nd, 2020. So there's a little bit of guidance there, but more is probably going to come out on that. But again, keep in mind too, this expanded FMLA leave is limited to a situation where you have to, where a school or a care provider is closed.
Okay, perfect. And I think that one of the questions was, and if an employer reduces an employee's scheduled work hours, can that employee use paid sick leave or expanded FMLA leave for the hours an employee is no longer scheduled to work?
Again, that's a reduction of hours issue. If the work is no longer there, that employee does not qualify under either of the expanded pay or the expanded FMLA.
Perfect. And then one final question that I have related to that, and it's probably more of a logistical question, but how do employees pay their portion of insurance premiums if they go on emergency leave?
How do the employees pay that?
Yeah. I don't have a lot of context for the question other than just how do my employees pay their portion of their insurance premiums if they go on emergency leave?
I have not looked at that. I'd have to look into that.
Okay, perfect. Well, that's okay. If we can, get an answer for that, we can share that out. So it's now 2:32. Huge thanks to our panelists for staying online, and those we still have quite a few people who are still on the call. Thanks for staying on extra. If other questions come up after you're kind of thinking about this, shoot them our way. We'll push them out to the panelists, but we'll make sure and share the recording. We'll share the presentation, and if we get any other questions, we'll share questions and answers out to you as well. But again, huge thanks to all of our panelists for staying on an extra half an hour, and just really appreciate everybody's time today. And hopefully this is really helpful for those that join in on the call as well. We haven't done anything like this yet, and I thought it was really important that we talk about all the other aspects in addition to some of those payroll protection plan and SBA loan packages. So with that, I'm going to sign off. But again, thank you everybody for joining us. Thanks to panelists for your extra time. We appreciate it. And let us know how else we can help you. So stay well, stay home, stay healthy, and we'll talk to you soon.
Thank you.
Thank you.